Hello, distinguished audience. I am Toluwani Festus Olushola. I'm a foreign level student of the Faculty of Law, Leeds City University, Ibadan, and I'm an undergraduate intern at Harlem Solicitors. Today, I'll be taking you through a critical appraisal of the case of Helios Towers and Isiaka Bello. But just before that, I would have you note that at the end of this video, you must have learned the constitutionality of proof of damage in a tort of nuisance. 2, you must have learned the harmlessness of a BTS site to the members of the neighborhood. Now, I'd have you note that Isiaka Bello built his house in the year 2000 and believed that a mast that was built in the year 2011 was capable of causing damage to him and members of his family. He also, in fact, believed that that was enough to constitute nuisance to him and members of his family. To this end, Isiaka Bello moved to the Ekiti State High Court and was of the form of submission that because the Helios Towers BTS site constituted and amounted and the great amount of noise to him and posed great health dangers to him and his family members, thought had been substantiated. However, the court was of the opinion that because Isiaka Bello failed to prove that he actually suffered any damage or any wrong as a result of the BTS site, he was unable to substantiate his claim of nuisance. To that very end, the court awarded 2 million naira damages to him on the basis that although he had failed to prove damage that he suffered, he still was able to prove that the Helios Towers had violated natural regulation. Now, Helios Towers found this unconscionable and moved to the Court of Appeal. They moved to the Court of Appeal on 6 grounds of appeal, and this formulated 3 issues. The first was whether the court was right to have upheld that Isiaka Bello substantiated his claim of nuisance. The second was whether Isiaka Bello was entitled to 2 million damages awarded to him. And the third was whether the trial court was right to have held that the natural regulation should be above the NCA 2003. Now, on the first issue as to whether Isiaka Bello had substantiated his claim of damage done to him by the BTS site, the court perused through several of cases, including J.A. Adediran and Interland Transport, and found that Isiaka Bello failed to prove damage, and in fact, the court gave damages to Isiaka Bello based on speculation because there was no damage done to him, and the court followed the case of Farami versus NBA to look at the fact that there was in fact no damage done to him, no wrong suffered, and none of that was proven in court. The court went on to be of the position that the trial court were erred and was wrong to have held that Isiaka Bello substantiated his claim of nuisance. And on the second issue, the court, following the laid principle of res ipsa loquitur, that since Isiaka Bello failed to prove any damage done to him as a result of the BTS site, he was not entitled to any 2 million naira damage. And the court was of the firm submission that at best, the BTS site was nothing to him because he was unable to prove it. The best he could come with was a statement from his doctor, although he did not bring his doctor to confirm the statements, which also led to speculation under the laws of evidence. On the third issue, the court was faced with the challenge of noting whether or not that particular natural regulation was of retrospective effect. The court had to line out exactly what it means for a law to be of retrospective effect. But the court ended up coming to a reasonable conclusion that because the BTS site was built before the natural regulation, that does not mean that the natural regulation was retrospective effect, following the fact that the BTS site did not come into operation until after the regulation had come in force. To this end, the court was of the firm submission that at best, although the natural regulation was violated, at best it was public nuisance, to which Isiaka Bello had no ground, no locus standi, and no case. To this very end, the court dismissed the claim of Isiaka Bello and threw away the judgment of the trial court. Now, I want you to note something. I said earlier that you would find out the harmlessness of a BTS site. WHO, NCC, and Dr. Emmanuel Nwokori, who was the chief pathologist of Garki Hospital, Abuja, in the year 2018, they all individually noted something. They noted that because of the height of a BTS site, most of its radiations go in the atmosphere and only a very minute amount comes to the ground. And that minute amount is not enough to form the type of radiation that will cause harm or even cancer. As I stated earlier, these three positions, these three authorities have come to a reasonable conclusion that the radiation from a BTS site cannot constitute nuisance and cannot constitute threats to the health. However, there is in fact ionizing radiation that can pose threats to the health. But I know you want to know where this comes from. To find more and to know more about this, I invite you to our website at www.harlemsolicitors.com, or you can find us on LinkedIn or Instagram at Harlem Solicitors. Thank you and enjoy the rest of your day.